Now it is my pleasure to call the case People of Michigan versus Jeffrey Scott Armstrong. Thank you. Good morning. You may begin when you're ready, and you may save time for rebuttal, but we ask that you keep track of your own time. And it is my understanding that we have 5 minutes for the ACLU as well.
Okay. And good morning, Your Honors. John Voitala, representing the appellant in this particular matter, the people of the state of Michigan. Certainly, attitudes towards marijuana have changed in the last few decades. And as evident by, if you're driving the streets of any particular city here in Michigan, you see the billboards for dispensaries, you see ads in the newspapers for dispensaries. Certainly attitudes have changed for the relaxation of marijuana laws. And that is certainly evident in the voter initiative that resulted in the passage of MRCMA. But one thing that MRCMA still finds to be unlawful is the smoking of marijuana in public, and especially in a vehicle or around a vehicle. And that's the starting point of this particular case, is that these particular officers were in an area. The Officer Eaton noticed the smell of marijuana and did an investigation of the vehicle based upon that. Upon doing so, simple Fourth Amendment applications applied after that. Following Mims, the U.S. Supreme Court case, the officer asked the defendant to step out of the vehicle. At the time he stepped out of the vehicle, that is the point in which marijuana has nothing to do with this case. At this point, the officer's partner, Officer Ganau, I believe is how you pronounce her name, she noticed the gun that was sitting at the feet of the defendant who was sitting in the front passenger seat. And at that point, there was probable cause. The defendant was committing a crime, the possession of a concealed weapon, and at that point, that probable cause allowed that officer to reach into the vehicle and retrieve that gun. That's what happened in this case.
So isn't the critical inquiry is whether or not the smell of marijuana alone
Yes.
is sufficient to establish either, I know the lower courts, and it was argued below by your office and others, that it was a probable cause standard, right, and Kazmierczak. So whether it's probable cause or reasonable suspicion, right, that your argument, your theory of how this is perfectly legal depends upon the smell of marijuana alone be sufficient to establish reasonable suspicion for the officer to be where she was at that time, correct?
Correct, and that was what the investigation was. She did indicate also that she saw furtive gestures. The lower court judge, the circuit court judge, Judge Hood, had indicated he did not believe her particular testimony in there, but he did find that she did find the smell of marijuana. While I say it's reasonable suspicion and not probable cause, as Kazmierczak says, Kazmierczak was the probable cause to search the vehicle, not whether or not it is proper or whether the smell of marijuana provides the reasonable suspicion to investigate in the first place. In Kazmierczak, it was a traffic stop involving speeding, so there was reasonable suspicion independent of the smell of marijuana.
Where do we draw the line with the smelling of marijuana? Because as you indicated, you know, on our drive from Lower Michigan, lots of shops, right? Marijuana shops, lots of billboards, and just like you're seeing an increase in that, you're also smelling an increase in marijuana. At least I've experienced that. Where, you know, I've been places and I don't think it's in use, but it has a very strong scent to it. So where do you draw the line between smelling marijuana and it could have been used prior to getting in the vehicle versus, you know, it's being used or was recently just used in the vehicle?
Okay. Well, I think the smell in itself, because it is a very distinctive smell, certainly would allow a trained police officer to recognize that at some point someone was smoking some marijuana. In this particular case, they were able to focus that it was coming from this particular vehicle. And so
But,
I would
but
think.
that's actually my question,
Right.
is at what point, I mean, where's the training to say it was smoked, within the last 5 minutes while they're in the vehicle versus it was smoked an hour ago?
Right. So reasonable suspicion itself does not require that you eliminate all innocent explanations for this. So it could have been that the marijuana was smoked before they got into the vehicle or not. I think where I would draw the line, at least for reasonable suspicion, is that, and I've certainly encountered this because, as you said, I've encountered the smell of marijuana quite often, just in my travels around the Detroit area, is that if you're able to determine that it's not just the smell of marijuana that's somewhere in the area, but determine that the smell is strong enough that you can pinpoint it to a particular vehicle or a particular person, independent of you seeing actually the smoke coming from them smoking it. If you're able to, the strong enough smell, which the officer is trained to do, as indicated in Kazimierz, what they said, if that smell is strong enough and you can focus it upon a particular individual, particular car, then that would provide the reasonable suspicion.
Well, isn't that, what I'm struggling with is all of those factors, a strong odor on a particular person sitting in a vehicle is potentially or equally 100% legal. So how can completely legal conduct, it's as much potentially legal as it is illegal.
Right.
How does legal conduct give you reasonable suspicion of illegal conduct?
Well, that's the point, is that the police do not know whether this is illegal conduct or innocent conduct, okay?
But doesn't reasonable suspicion to support a Terry stop require more than just a hunch or a guess or a chance that it might be illegal?
That's true, and that's why I indicated it's more than just the smell of marijuana, it's the intensity of the smell and able to focus it upon a particular individual, particular car. And so, as I also indicated, is that even if there are innocent explanations for why the smell of marijuana was coming from this particular individual or particular car, that does not diminish reasonable suspicion. Is the point of reasonable suspicion is that you have a suspicion, more than a hunch, but less than probable cause, that a particular crime is occurring. You go and you investigate. You investigate to determine whether a crime actually is being committed or whether a crime is not being committed. If the crime is being committed, you could, oh, I'm sorry.
No problem. I have a question, and I think the line of questioning has been really outstanding, but I guess the question I have is, if this court were to deny, what would the actual real-life consequences of that be as it pertains to driving in marijuana?
If the court was to deny what?
If we were to uphold the fact that there was no reasonable suspicion to pull over or no probable cause based on the smell of marijuana, what would the actual consequences of that be as it pertains to driving with, the smell of marijuana or the driving with marijuana?
Well, and I think you've hit upon an important little fact in this particular case, too, is because this was emanating from a vehicle. And this, using the facts of this particular case, it was emanating from a vehicle. And so we are going to even more of an extended of whether or not this person is driving under the influence or is in control of a vehicle, the driver itself, not the defendant in this case, whether the driver was under the influence. And so I think the smell of marijuana, if you smell the marijuana in a moving vehicle, it's maybe a little more difficult to come up with reasonable suspicion. I will concede that point. You would probably need something a little bit more to get you to the reasonable suspicion if you're driving on the freeway and you just happen to smell the marijuana, because it's difficult to pinpoint. But I think in this case, where the smell of marijuana was emanating from the particular vehicle, you're able to pinpoint it to that particular vehicle, and there is a person that's sitting in the vehicle in the driver's seat. I think then that does add more to the reasonable suspicion analysis, in that you have to suspect whether or not this person has been driving under the influence.
But then if you go up, according to the video, they go up and there's, they deny using, I don't know that there was anything visible in the compartment, that there was evidence that they were actively using marijuana. Why then was there a reason to then ask defendant to step out of the vehicle.
Well,
Because
mi-
obviously, we're trying to figure out, was there enough to get to the plain view of the
Right,
gun?
so the reasonable suspicion that gets you to investigating the particular individual, what MIMS state from the US Supreme Court case has said, you don't need additional reasonable suspicion to ask that person to exit the vehicle. The Fourth Amendment does not require anything additional, just the fact that there is reasonable suspicion to do an investigation as part of the investigation because this involves a vehicle, and vehicles under the Fourth Amendment are given special status. You are allowed to ask that person to exit the vehicle to further the investigation.
Sure, but Terry also stands for the proposition it's supposed to be limited in scope and limited to whatever that initial reason was.
Right, but if the police don't have to just listen to what defendant has to say when he denies his crime, because that's going to happen in every case. Is that if you ask somebody,
Is there a basis, or would it, to analogize this to alcohol? Is the smell alone of alcohol sufficient reasonable suspicion?
certainly,
Is it sufficient to support a Terry stop?
certainly the smell of alcohol on someone's emanating from someone's breath or from their body as they're getting into a vehicle, yes, that would give
So
reasonable suspicion.
say similar circumstance, right?
Right.
I think in most cases with alcohol, right, the reasonable suspicion is probably supported by a traffic violation, right? Swerving, speeding, something. But say a similar situation where the officers come upon somebody sitting in a parked car, which could still potentially be illegal, right? Consuming it is not illegal. Consuming alcohol, having consumed alcohol alone is not illegal. Being intoxicated and in control of a vehicle would be. So if a similar circumstance, not any driving sort of situation that gives you reasonable suspicion, would the smell of intoxicant, of alcohol alone be sufficient reasonable suspicion?
I would say that it also involves, as any reasonable suspicion analysis is, depends upon the circumstances.
Factual
So the circumstances that I would address for that is, much like with marijuana, it is illegal to be consuming alcohol in public. And so if you, let's say the circumstances are, you see someone outside of a bar, they have a red Solo cup, or they have a bottle in a paper bag, and you happen to walk by them, and you do get the smell of
But those
of
these
alcohol.
are the other indicia, right? We're talking, and perhaps other indicia such as seeing smoke coming out of a vehicle or something thrown out of the vehicle, or remnants of having consumed marijuana in the vehicle. All those other indicia are still actually relevant under the Court of Appeals test, right? But the question is odor alone, and I'm wondering if there is an analogy. Like, is there a strong enough odor of alcohol that is sufficient to constitute reasonable suspicion to justify a Terry stop?
So the consuming of the smell of alcohol alone on someone that is in public, just
Right.
there's no other indication that they are actively drinking.
Or sitting in a vehicle.
They're sitting in a vehicle. Well, I guess, again, that would depend upon the location of that particular individual in the vehicle. If they're sitting in the driver's seat and you get a strong smell of alcohol coming from that person, then I think gives you reasonable suspicion.
And does our case law support that? I mean, does our current status of the law say that if you odor alone sitting behind the driver's side of a vehicle may be reasonable suspicion? I'm just wondering, I mean, it would seem to have some analogy.
Yeah.
Right?
I'm not aware of any case that either says yes or no, that the smell of alcohol alone from an individual. But I think if the police are investigating a particular car, like on a traffic stop for speeding or something, and they do smell alcohol coming from the driver, I think that does give them at least reasonable suspicion to investigate further whether it is,
Consumption or
yeah,
intoxication.
correct. Whether it's not, it's doing the field sobriety test.
Isn't
or
it a
not.
better analogy to think of open intoxicant in a motor vehicle? Because this isn't an operating offense, I don't think, was being investigated here because the vehicle was parked.
Right, exactly.
So it's
Well,
more-
under the law, it could still be, if the driver was smoking marijuana in a parked vehicle, there can still be some lawful part of that. But
Right, I understand.
Right.
I just mean to the analogy with operating and looking for indicia of a vehicle that's swerving or driving erratically is a little bit different, but the analogy would be if the officer came up to a passenger in a motor vehicle and parked on a public street and smelled the odor of intoxicants, would that be reasonable suspicion to investigate whether that person was drinking in the vehicle and therefore would have an open intoxicant violation?
With the smell alone and with no other indications of, as I said, a bottle or a cup or some notice that there is an actual alcohol or has been consumed in the particular vehicle, I would think that probably the smell alone is not sufficient. But I think analogizing alcohol and marijuana in a particular instance, I don't know if that is a clean analogy to be
Well, and
made.
it's more complicated too, because even there is no circumstance in which having an open alcohol container in the car is legal, but it is legal to possess marijuana in the vehicle, right? You can transport it, you can do that. So it's again, legal conduct to have that. What's illegal is active consumption in the vehicle, right?
Right, and
Or
I
in
think,
public.
and I think if you're going to go down the road into Kazmierzak and you're going to analyze whether Kazmierzak is still, and I don't think you need to, but if you're still going to analyze whether Kazmierzak is still good law, I think you're inevitably going to get to the question of Kazmierzak said whether it's fresh or smoked, it means the same thing. I think what Mertma does with Kazmierzak is raise the question as to whether smoked marijuana and fresh marijuana are the same.
Or distinguishable.
Are
right? Yeah.
distinguishable. I think because you have burnt marijuana in this particular case, I think the burnt marijuana is indicative of recent use. And the recent use is the reasonable suspicion to investigate as to whether or not the using of the marijuana has occurred in a public place, which is unlawful.
I've got a question for you. You can give me a short answer, and then when you come back up, maybe elaborate further after you hear.
Well, I did forget to reserve the 2 minutes. I was
You're
looking
gonna
at my
have
time.
one, you're gonna have
we're gonna
1
give you a
minute.
minute.
I'm going to have 1 minute, so
1
I
minute.
will reserve my
A-
1 minute.
A
and
brief
I'll-
answer to Justice Sarah, and then you'll have a minute.
Let's assume you're right, the officers were able to lawfully seize the vehicle and investigate and remove defendant from the vehicle, and assume further the handgun is still not in plain view. Is there any evidence, in addition to the smell of marijuana, that would have given the officers probable cause to search the vehicle?
Well, obviously, in this particular case, Kazmierzak is still good law, and so they would have the probable cause under Kazmierzak if we get down to that particular level to search, and I think it would be, they're in good faith, would rely upon Kazmierzak to do so. I think,
You can give it to me when you come back up.
Right.
Is there anything else besides the smell of marijuana? And you can give me the answer when you
aside
come
from,
back up.
yeah, aside from the gun and aside from the marijuana,
Well, if the gun's not in plain view, is what I'm saying.
if it was not in plain view, would they have been able to go into the vehicle under Kazmierzak? Yes. I mean, sorry, you're saying without the smell of marijuana, would they have been
No, no.
able to go in there and
Yeah,
search
but that's
it?
correct.
Right. I don't see a reason for doing so, but in this particular case, because he had stepped out and in plain view, they did see the gun, there was probable cause to go.
Okay.
Thank you.
Good morning, Justices. My name is Andrew Sullivan. I have the distinct honor of representing Jeffrey Armstrong in this case. I welcome your questions at any time. Apart from answering your questions, I did have one point in response to the government's arguments just now. It seems that the government is arguing this is more than just the smell of marijuana, but that it's also the smell of burnt marijuana, or it's also the smell of a localized sort of way in which the officer is able to smell marijuana. And I just want to emphasize that police did not find any marijuana in this car. And so the court should be concerned about the rate of false positives. And I think that the Minnesota Supreme Court, when addressing this question, actually cited to a study that found that in 3,300 searches of vehicles premised on the smell of marijuana, officers only found marijuana in less than 10% of those cases. And actually, Kazmierczak speaks to the fact that there needs to be some evidence of an officer's training and ability to smell, certainly any distinction between burnt versus raw marijuana. But again, I think that the court should be concerned about the rate of false positives and the fact that there was no marijuana found in this case.
Can you help me? So, picking up again, and maybe it's an inapt analogy, but the presence of alcohol, whether it's from consumption or open alcohol, there is some Court of Appeals authority, obviously not binding on us, but that says that a strong odor of intoxicant standing alone can be sufficient to support reasonable suspicion. So, in light of that, what do we say about why can't, assuming even under Kazmierczak and after Mertma that probable cause is sort of off the table, or that the Court of Appeals sort of analyzed that correctly of it takes more than that, why isn't the smell alone at least enough to establish the lesser standard of reasonable suspicion?
The smell of marijuana and the smell of alcohol are chemically different, and so I think that the legal analysis has to be correspondingly different. When officers smell alcohol, they're usually smelling it on someone's breath. The smell of marijuana, the chemicals that produce the smell of marijuana can adhere to clothes and upholstery, fabric in a car, and that smell can linger for days, hours, unlike the smell of alcohol. And so when an officer is smelling alcohol, it's telling them a lot more about, one, who is consuming that alcohol. They're smelling it on someone's breath. They know who's consumed it. And two, how recently it's been consumed. And that information is not available to the officer just based on the smell of marijuana, because it could be that the individual was just in close proximity of someone else who is smoking marijuana, so the officer doesn't even know, is this the person who has consumed marijuana? And also how recently that person has consumed marijuana. And so I think that those distinctions...
But do we really need experts to know? I mean, it's so prevalent. I'm driving down 96 in my car on the freeway, and I'll go by a car and I can smell a strong odor of marijuana. Do we really need experts to tell us that's a really strong smell of burnt marijuana? That's not fresh marijuana that hasn't been smoked, and it's recent. I mean, isn't that ordinary observation? Do we really need that? And if there is this strong smell coming from a car with a person behind the wheel, under Terry, isn't that enough for reasonable suspicion to at least go on and ask more questions and find out what's going on?
So first, taking the first question, it's the smell being very prevalent and people feeling as though we can all identify that's the smell of marijuana. I'm not disputing that, but I am disputing whether or not our simply smelling it is actually proof positive that it is where we think we'll find it.
But Terry doesn't require proof positive, right?
Certainly, but Terry does require reasonably objective, particularized suspicion of criminal activity, and given that marijuana is legal to have for a person to have on their person, and it's legal for a person to have consumed yesterday, it's legal for a person to have been in a room with someone who's consumed yesterday. All of those possibilities, I think, discount an officer feeling as though they have reasonably objective, particularized suspicion of criminal activity.
So what more do you need? Let's use the circumstances of this case. If smell is not enough, it's smell and what? Can you give us some examples of what could have been enough?
Certainly, the circuit court made particular note of the fact that the officers did not see any lit cigarette, any smoke billowing out of the car. Those would have been indicia of present consumption. And so officers would have been more justified in having some concern that maybe a person is, again, the present consumption on the roadway is only a civil infraction. So I'm not sure that even gets them suspicion of criminal activity. But if maybe in addition to seeing the marijuana in the car, if the car was running, if the car was moving, then there may be concerns that somebody is operating a vehicle under the influence of intoxicants. But none of those things are present here.
So I'm sorry, so if Justice Ara's example of smelling a strong odor and the car moving, that could have been enough?
I'm not sure if that alone would be enough, but if it was also true that the officers saw a lit cigarette or saw smoke, then the officers would have there's a greater probability that there is present consumption at the same time that there is driving.
Or they swerved or something.
Yeah, my
Right.
concern with that, though, is I think that's what the Court of Appeals is saying is maybe sufficient to establish probable cause. And we know reasonable suspicion is a lesser degree, a less burdensome standard, right? So is there any, and what you're saying to me sounds like, well, reasonable suspicion and probable cause are going to sort of collapse on each other in this instance. Is that true, or is there some daylight between what is enough for probable cause, but you know, you need a little bit less for reasonable suspicion?
I think there is daylight, and as Justice Welch is indicating, if a car is also swerving, then that's, I think now there's actual probable cause of a traffic violation, of a person actually being intoxicated, in addition to just the possibility that somebody in the car is consuming marijuana. I think that there is daylight, but I think that the statistics around and this this study that was cited by the Minnesota Supreme Court suggests that there is a concern with operating on the basis of smell alone, whether it's in a finding of reasonable articulable suspicion or probable cause.
So
I'm sorry, is it not illegal to consume or smoke marijuana in the passenger vehicle, in the passenger seat of a vehicle while on a public street?
I believe that is carved out from the MRTMA as not, the MRTMA is not making that conduct legal, is not protecting that conduct.
So why do you need to have the vehicle swerving like a drunk driver? If there's strong odor coming from the vehicle and you're on the public street, isn't that enough under Terry to investigate further?
I'm sorry, in your question, is the officer also seeing indicia of present consumption?
Doesn't see the consumption, but, I mean, I'm telling you from my personal experience, I can tell the difference between an old odor of marijuana and a very fresh odor of marijuana. I mean, the strength, I don't think it takes an expert to figure that out. And I think, I don't think it's an unreasonable assumption that police officers know more than me. So if you go by a vehicle and there's a very strong odor that seems to be coming from that vehicle, and it doesn't require that there be operating of the vehicle. If you're smoking marijuana or consuming marijuana, it doesn't even have to be smoking, I guess. If you're consuming marijuana on a public street, that's not protected conduct. So doesn't that give rise under Terry to investigate further?
And again, my answer is no, because there's no indication of present consumption, and I understand Your Honor has a position about your own ability to distinguish something that's been smoked recently, but again, it could have been, that could be a fresh odor that the passenger of the vehicle was in close proximity to, again, earlier in the day.
It could have been, right? It doesn't have to be rock solid. We're talking about the first level is Terry. And does it have to be proof positive under Terry? No, reasonable suspicion.
It doesn't have to be proof positive, but the Ohio versus Terry decision, which gives officers this ability to conduct an investigatory stop, goes on at length about how the officers in that case observed John Terry to be, the officer had made observations over some 30 or 40 minutes, And I think Chief Justice Earl Warren makes a point of the fact that the officer is able to distinguish this person's behavior as distinct from others who are simply window shopping, right? The officer's concern was this is a person who's preparing to rob a store, and there was a particularized basis to believe that this person was doing something more than simply window shopping. And my argument is that when an officer is simply smelling marijuana, their suspicion is of the analogy to window shopping. The likelihood of an innocent explanation is too high to permit the officers to be essentially seizing everybody on the commercial in Terry versus Ohio, for the officer to be seizing everyone on the block on suspicions that they're preparing to conduct an armed robbery just because they're peering into the window of a store.
And I think, counsel, it's, I mean, wouldn't it be that we sort of have a clash? We have this legalization of the use of recreational marijuana. We have a purpose statement in the law about wanting to make sure people can freely use it without, getting in trouble. But then we also have this carve out for using it in a vehicle. And obviously, so you have this right in other contexts to use it freely. And then obviously what we're grappling with is, but there are some carve outs that accept that. So I mean, I hear what you're saying.
Right.
That because it's very legal, now it's like, well, if you smell it, does that mean you were doing something unlawful in the vehicle? So that,
Right.
from my perspective, that's like the difficult thing we have to grapple with.
And whether that conduct is a civil infraction or a misdemeanor, does that inform the question of reasonable suspicion or probable cause?
On the question of reasonable suspicion, Terry versus Ohio makes clear that the officers need to have reasonable articulable suspicion of criminal activity.
Criminal activity.
So I think that, yes, the suspicion of a civil infraction is not enough for an investigative stop under Terry.
And was it your position that what potentially occurred here, if, I understand you're saying it didn't, but it was a civil infraction?
Yes, and I think that the government in their brief on page 10 of the brief at the Court of Appeals level concedes that public consumption of marijuana in public is a civil infraction.
But there was also a driver in control, in the driver's seat, right, who arguably was in control of the vehicle, and driving is a criminal misdemeanor, or being in control of the vehicle, right, under...
Right, that is criminal. It doesn't justify officers seizing the passenger of the vehicle. And even if this court found that there is reasonable articulable suspicion of criminal activity on the basis of the smell alone, as the court, I think, earlier noted, under Florida versus Royer and the United States versus Rodriguez, any seizure, any investigative stop has to be tailored in scope and duration. An officer can only conduct that seizure as long as is necessary, a prudent officer, to confirm or dispel their suspicions. And in this case, once the officers get close enough to the vehicle to see that there's no smoke and there's no lit cigarette, both individuals are able to answer questions coherently. They don't see any other indicia of intoxication. That seizure needed to end under Florida versus Royer and United States versus
But then that
Rodriguez.
goes into, like, I believe the prosecution's theory is that they needed reasonable suspicion to be in the position in which the officer testified or took the position that she could see the weapon in plain view. So yes, maybe the investigation at that point should have been limited in scope, but then the weapon was visible in plain view. Do you want to address, I understand that the trial court, and this is a little bit of a unique way that this record was created, right? We don't have witness testimony in that. We have limited to a body cam and a few lines from a police report, right? And so that was stipulated by everybody that that's what we're going to decide this case on. And so, but their contention is that as long as they were legally at the window, then the vehicle was seen in plain view.
The
weapon was seen in plain view.
I understand the question. The trial court made a factual finding that the gun was not visible to the officers until after Mr. Armstrong was removed from the vehicle.
What was that finding based on?
That was based on the trial court's ability to watch the body-worn camera, and within the body-worn camera, one thing that the trial court highlights is that after the gun is found by the second officer, Officer Ganaw, that the gun is removed from the vehicle by that second officer. The first officer turns to the second officer and says, "Ooh, let me see it." And the trial court makes a finding that the officer saying, "Ooh, let me see it," is consistent with their not having seen it before, seeing it for the first time, essentially. I think that the Court of Appeals also noted that the officer, Corporal Eaton, the first officer that's speaking to Mr. Armstrong.
But
Perform-
I'm sorry. I just want to make sure that we have the facts of the records straight. Prior to that, though, didn't the officer say that he has a pistol in the car, and when the defendant objected, she said, "You can see it," before she said, "Let's see it real quick. Oh, nice."
No, that's not my memory of the body-worn camera. And
I think, wasn't it that the officer, was at the and asked, you can hear her off camera saying, "Do you have a CPL?"
Right.
And he says no, and then when Eaton goes back and says, "Hey, let me see it."
that's correct.
I've got one more question for you. I know your time is up, but I drove 7 hours to get here, so I'm not going to let you down until we're done with the question.
Fair. I drove as well. It's a beautiful drive.
So we can take as much time as we need. Assume the officer had legal justification to seize the vehicle and investigate whether illegal activity had occurred. Is there any reason why they would not have been able to order the occupants to exit the vehicle during the course of the investigation? Doesn't officer safety concerns apply just as much here as it would in any other traffic stop?
Well, I think, first of all, I dispute whether this is a traffic stop. There's no.
No, I'm not saying it
Yeah.
isn't.
Okay, sorry.
But officer safety concerns, legitimate, right? The Supreme Court of the United States has told us that's a very legitimate reason to take precautions. And I'm asking whether, in this circumstance, wouldn't those safety concerns be just the same as if it was a traffic stop?
I would cite to this court's earlier opinion, this term in People versus Duff, that whether a police officer's prudential procedures are justified has little bearing on whether a reasonable person might feel free to leave or otherwise terminate the encounter. The position that officer safety is not a substitute for reasonable articulable suspicion, and so if
No,
officers.
but the question I asked you to assume that existed already.
If officers had reasonable articulable suspicion, I think Terry versus Ohio holds that once officers have reasonable articulable suspicion and then they also have a basis to believe that a person is armed and dangerous, then they conduct a pat down. And so I think that following from Terry versus Ohio, there should be the first and then also the second step where there's some basis to believe that this person is a danger in order to take the additional to escalate to the additional step of removing somebody from a vehicle. Pennsylvania versus Mims, of course, is distinct because it's a traffic stop and officers had probable cause, having seen a traffic violation. Here, if we're sort of bootstrapping officer safety on top of the reasonable articulable suspicion, I think that that's an extension of Mims. It's not necessarily consistent with Mims.
Thank you.
Thank you. Thank you all.
Thank you, Chief Justice, and may it please the court. My name is Ramos Badoud. I'm here on behalf of Amicus Curiae, ACLU of Michigan. Now, the defendant appellee has already addressed the core argument about the role of the smell of marijuana, and we agree with those arguments wholeheartedly. I want to instead focus my time on two unique arguments made in our brief. The first being that under Terry v. Ohio, police stops that are based on reasonable suspicion cannot be used to investigate civil infractions categorically. And the second, if I end up having time, is that the search and seizure provision of the Michigan Constitution provides greater protections than the Fourth Amendment to prohibit police stops based on nothing more than the alleged smell of marijuana. Now, as to that first argument about the categorical limits of Terry stops, the prosecution today, and in this case, makes a dangerously broad argument that police officers can conduct Terry stops based on reasonable suspicion of civil infractions, such as smoking marijuana in public. However, Terry v. Ohio doesn't allow the use of police stops to investigate civil infractions if they're based only on reasonable suspicion of that offense. Instead, Terry and the case law developing it repeatedly make clear that only indicia of potential criminal activity can provide reasonable suspicion to conduct an investigatory stop, and I welcome the court's questions at any time.
So can you lay out for me what is, I believe the prosecution says it's both criminal misdemeanor and civil infraction. What is what, right? Like consumption on a public street is a civil infraction.
That's correct, Your Honor.
Consumption in a passenger compartment of a vehicle is,
It is also a civil
Civil
infraction
infraction.
for the passenger.
what about somebody sitting in the driver's seat of a vehicle?
So being in control of a vehicle while intoxicated by marijuana or while consuming marijuana is a misdemeanor, and that would require this court to reach that core primary argument about what role the smell of marijuana alone plays in reasonable
Right.
suspicion analysis. We think that the smell of marijuana alone, as the defendant argues, does not provide reasonable suspicion to conduct a stop even on a parked car. But as to the civil infraction of smoking marijuana in public, whether or not there was reasonable suspicion, a police officer couldn't have used a Terry stop to investigate further because the Terry stop, the Terry doctrine is limited to criminal activity.
Is your theory, though, that for civil infraction, that the relevant standard under Terry should be the higher, the more burdensome probable cause standard?
Right. So essentially the rule we're advocating for here is a probable cause minimum for investigating civil infractions. Terry v. Ohio recognized a limited, very narrow exception to the general probable cause requirement because it recognized the government's interest in fighting, detecting, preventing crimes. It recognized that was a compelling enough interest to warrant a bit more flexibility than what probable cause provided. But the interest in investigating civil infractions isn't as compelling, isn't as urgent as fighting crimes. And so the police shouldn't be afforded the same level of flexibility for civil investigations that Terry provided for criminal investigations. And that's
Counsel, can you help me understand, I understand what you're talking about as far as reasonable suspicion versus probable cause, civil infraction versus not. But I'm looking at the law, and I know this is getting into the weeds of the law, which we have not asked the parties to totally brief here, but we talk about consuming marijuana while operating, navigating, or being in physical control of any motor vehicle, skipping ahead, or smoking marijuana within the passenger area of a vehicle upon a public way. That's a misdemeanor. That's how the law is drafted. How does that not apply here? How do we jump to just public use, which is a civil infraction?
Well, I mean, I don't think it's in dispute that one of the alleged bases for the police's stop here was the civil infraction of smoking marijuana. That's what the prosecution alleges in their briefing. That's what the defendant agrees with.
So we're just going with based on how the case sort of came to us?
Right. For this
Okay.
particular case, the prosecution maintains that the police were investigating the civil infraction of smoking in public. That's what we have to respond to. And what we believe is that reasonable suspicion or not, the police did not have a Terry stop on their investigative tool belt for investigating that civil infraction.
Go ahead, I'll let you finish before I ask my question.
No, go ahead. Go ahead.
Well, I don't read the prosecution's brief the same way you do, but the facts are the facts and the law is the law. What we have here is a vehicle with two people in it and a strong smell of marijuana. Does that not give rise to a reasonable suspicion of a misdemeanor under our law?
We believe not, Your Honor, and I think it's I understand your questioning of the defendant and of me. It's a jarring kind of new landscape after the MRTMA was passed, where the use and possession of marijuana is generally lawful, except for a limited set of exceptions where it remains a misdemeanor or a civil infraction. And I think I want to point this court to the U.S. Supreme Court's decision in Reed v. Georgia to kind of give a helpful guidepost for analyzing reasonable suspicion under this kind of post-MRTMA landscape. In Reed v. Georgia, police officers stopped 2 individuals at an airport on suspicion of drug trafficking. What they were going off of for that stop was simply that 2 individuals arrived in the early morning with little to no luggage, and they were standing in different places in line even though they were clearly together. What the Supreme Court said in that case was that all of those factors together, that totality of the circumstances, and I quote, describes a very large category of presumably innocent travelers. And I think that is a really helpful guidepost for the post-MRTMA world in Michigan, is that the smell of marijuana now describes a very large category of presumably innocent people. And so the police officers, I understand it might be a difficult change because it is a substantial change to the criminal law and procedure in Michigan. But now, after Michigan voters passed the MRTMA, the smell of marijuana points to a very large category.
Aren't there a lot of situations where things are highly regulated, like controlled substances, prescription drugs, where you can use them lawfully in certain situations and not in others? Even possession of a firearm, highly regulated, lawful in some situations and not in others. And we ask police officers all the time to make difficult decisions when somebody is possibly violating the law. Why is this? You seem to be trying to create this big bubble around marijuana that you can't go anywhere near marijuana because it's a zone of, because of this new law. I sort of disagree with the premise, this jarring change. We have changes to the law all the time. Something's made illegal that was legal before. Something's made legal that was illegal before. That's what's happening here. And so why isn't it just a simple question of, if this is a misdemeanor, which I think it pretty clearly is, because this conduct is an exception to the protections under the MRTMA, and if it's true that it's a criminal offense, why can't the police investigate it like they can every other criminal offense? Why should we treat this one differently?
Well, so 2 things to that, Your Honor, if I might. I know my time is up, but the first thing is that marijuana is scientifically unique for the reasons that the defendant mentioned. The smell of marijuana can linger on someone's body, breath, clothes, upholstery for hours, maybe even days at a time. And so we think, this uniqueness about marijuana, I think, is warranted in that simply the smell of marijuana doesn't mean that someone is actively consuming, doesn't mean that someone's intoxicated. And the second thing I'll say is that the police still can investigate unlawful forms of marijuana use and possession. But what Terry requires is indicia of criminal activity.
They have to find somebody smoking a joint, or that's it?
Not necessarily
That's all
someone
the
smoking a
room that we
joint,
have
but for example, the conduct alleged in this case, whether it's smoking in public or consuming marijuana while in control of a vehicle, you should be looking for
It's almost like
indicia.
you're arguing we can't have circumstantial evidence of this offense.
Well, I think the circumstantial evidence that would rise to the level of reasonable suspicion in this case would be things like smoke emanating from the vehicle. If the police had conducted simply a consensual encounter, if Officer Eaton had walked up to Mr. Armstrong without the other officers surrounding the car and then had seen a lit cigarette on the dashboard or other marijuana paraphernalia on the dashboard, officers can still conduct consensual encounters. What happened in this case, however, is 5 officers surrounding a vehicle simply because they smelled marijuana. So I want to emphasize that what we're arguing here isn't to remove the entire investigative tool belt from police officers when marijuana is involved. It's simply removing certain tools on the tool belt when there's just the smell of marijuana. Officers can still conduct a consensual encounter. Officers, if they have probable cause of a civil infraction or reasonable suspicion of a crime, can still conduct a Terry stop, can still arrest if they have probable cause. But it's really about the smell of marijuana alone giving rise to reasonable suspicion. And that's really just one tool on a large tool belt that police officers maintain after the
Counsel, does it
MRTMA.
matter? I know Minnesota grappled with this, and they cited to data that only in 9.4% of the cases, based on odor of marijuana, did they find actual marijuana. Does that matter to our analysis?
I think it's helpful background. I mean, obviously, a crime is a crime, and if police officers are investigating a crime, the likelihood of recovery is I think is helpful and relevant. But what matters more for in jurisprudential terms is whether or not there was the adequate level of suspicion to initiate the stop. And in this case, again, there was a stop. Officers surrounded the car. All forms of egress and ingress were blocked. But all they had to go off of was smelling marijuana as they passed the vehicle. Not particularized to the driver, not particularized to the passenger, but simply smelling marijuana as you drive a vehicle, I don't think rises to the level of reasonable suspicion for the reasons I pointed to in Reeve v. Georgia. It now, after the MRTMA, describes a very large category in the state of Michigan of presumably innocent people. And I think given the change in the law, police practices need to adjust a bit. And that's, it boils down to the purpose of the Fourth Amendment, which is to restrain police conduct. Not to eliminate police discretion, but to restrain it so that it prevents unreasonable searches and seizures. And I believe that what happened in this case was an unreasonable seizure.
The Michigan rules of evidence permit a court at any stage of the proceeding to be able to take judicial notice of a fact. Do you disagree with the notion that the everyday person can tell the difference? Not even the trained police officer, but the everyday person can tell the difference between a strong smell of freshly smoked marijuana versus the smell of marijuana that is hours or days old?
I don't know, and I don't think the average person can do that. But even if there's an easy way to distinguish between freshly smoked marijuana and marijuana that was smoked hours before, I think this case actually presents a perfectly good example why simply the smell of freshly smoked marijuana isn't enough for reasonable suspicion. It could have easily been the case that Mr. Armstrong, who was a passenger in the car, had smoked marijuana in a home minutes before entering this vehicle. And so I don't think the freshly smoked nature of marijuana necessarily is unique in that it gives rise to reasonable suspicion versus just the smell of burnt marijuana.
We all agree reasonable suspicion is less than probable cause. Once you're sitting in the car and there's this strong smell, why isn't that reasonable suspicion?
Well, I mean, reasonable suspicion.
Maybe it is innocent, maybe it's not. But I have reason to think there may well be a misdemeanor that's been committed here. Let's go to the next step.
Right, but Terry v. Ohio, I mean, reasonable suspicion is looser than probable cause, but it's still a minimum that rises above the types of inchoate hunches that Terry v. Ohio was talking about. And what the MRTMA sought to do, both in its purposive section and its operative terms, is to sever that hunch, that connection between the smell of marijuana and assuming that, something around me, something criminal must be happening around me. I think that was the purpose of the MRTMA, and it accords with Terry v. Ohio and the case law developing it.
Thank you.
Thank
You've all
you.
been very helpful.
Thank you.
Why didn't your office ask for an evidentiary hearing?
That is something that, as the chief of training for our office now, I have yelled at many people in our office for not doing so.
Because it puts us in an interesting position on appeal where if the officer had testified that she saw the gun in plain view, then I think unless there's contrary evidence, it would be clearly erroneous for the trial judge to find otherwise. But now the judge gets to apparently find whatever he or she wants based on some stray comments in a video. What are we to do with that?
I don't disagree. There really should have been an evidentiary hearing in this particular case.
It's your burden, just so the audience understands, right?
Exactly.
To prove that the brief investigatory stop under Terry was lawful. We're not talking about arresting anybody. The question is whether there can be a brief detention to further investigate whether criminal activity occurred. And that's your burden to prove, right?
Correct. Certainly we would have been in a much better position as the prosecution arguing this in the circuit court if there would have been an evidentiary hearing. But I still feel as though the facts that do exist.
And just to clarify one further
Sir.
thing that you said earlier, you said that the officer, somewhere there's an indication, I haven't found it in my materials, that there was a furtive gesture in the car. Where did that come from?
That came from the video, Your Honor.
So
Is
the-
that she,
Made mention of that?
after the actual stop, the video keeps going on for several minutes. And in in the video,
The
that
audio,
particular
isn't it
officer,
the
Officer
audio?
Eaton, states many times that I saw a furtive gesture, I saw a furtive gesture.
Does she specify when she saw it?
She indicated that she saw it as they were walking up to the car.
And again, just for the benefit
Which
of.
we have video of, that
Correct.
shows her walking up to the car.
Yeah. And
For
I'll
the-
concede that the video doesn't show
Doesn't
any
show the
furtive gestures
gesture.
prior to her going to the car.
Yeah, for the benefit of the audience, isn't one of the reasons the police might come on both sides of a vehicle is because they're concerned about officer safety?
Correct, Your Honor.
And if there's an officer who thinks there's a furtive gesture in a car, it might be something like putting a gun on the ground in the vehicle or trying to place it in the console or under the seat?
Exactly.
All right, so this is why this is sort of standard police practice.
To go to both sides of the vehicle. And also, in this particular instance, because they were investigating both the driver and the passenger for the smell of marijuana, which
Well,
is.
there were 5 officers there around the vehicle, and 4 of them around the vehicle by the time that Eaton walked up, correct? But they were there to look for probationers or parolees,
It was, it was a checkup on a parolee that lived in that area, correct?
not one of the occupants of the vehicle.
Not one of the occupants of the vehicle, right. So, 2 things I did want, as rebuttal, I did want to touch upon, and
Very briefly.
very briefly, because I know we're way past it.
But I hate to keep interjecting. On the issue of whether it's a misdemeanor, do you agree with the amici counsel that you didn't argue this was a misdemeanor offense? You argued it was a civil infraction?
Wholeheartedly disagree that I didn't argue that this was a misdemeanor, because part of it is the fact that the driver, whether or not the driver was smoking marijuana, that is a misdemeanor. And that's what they were also investigating. They were investigating, it was sort of a dual investigation. One being the driver, whether the driver is committing the misdemeanor of smoking, being under intoxication or smoking in the vehicle, under the control of the vehicle, or the passenger was smoking within the confines of the vehicle or smoking in public. So you can't parse out that we're only investigating the passenger for a possible civil infraction, but we're also, we have reasonable suspicion to investigate the driver.
But how do we know what they were investigating if we didn't have an evidentiary hearing?
Because.
I mean, it seems like we have to kind of know, right? We're just going to assume both officers, they were investigating both things, just take them at their word for it, even though we don't.
The investigation was for the smell of marijuana emanating from this vehicle. There's 2 individuals in there. The investigation is to both individuals. I mean, that's what's on the video. So, going back to what I wanted to rebut on, is first of all, is that I will agree that marijuana does have uniqueness, and the fact that we're way past the days of Cheech and Chong, where the police in the movie come up to a vehicle, and I'm dating myself, I know entirely by saying Cheech and Chong. Police come up to a vehicle and smoke is emanating out of, and they have joints. My experience now is that most people that are smoking marijuana are using vape, which is very, the water vapor that is used in the vape dissipates very quickly. It's not a joint. It's not something that they're physically holding and rowing for the marijuana. It is like the marijuana, I don't know how the vape's used, but it is not as easily apparent from smoke and roaches in the
But it creates
ashtray.
just as much odor.
Correct?
But it creates just as much odor.
It does.
vape.
It also
Right.
produces visible smoke.
But it quickly dissipates much quicker
Sure.
than the smoke. So that's the first thing I wanted to mention. And I think we did address the second thing I did want to mention, which was which was relating to Justice Viviano's question. Other than that, any further questions?
What are you asking the court to do?
What I'm asking the court to do is to reverse what the Court of Appeals did, which was to find that Kazimierczak is no longer good law, because I don't even believe that we should even be getting to the question of Kazimierczak.
Because the question is about reasonable suspicion, right?
Right,
And the Court of Appeals missed that somehow, right?
exactly.
So where do we send the case if we were to vacate, if a majority agreed that we should vacate the Court of Appeals opinion and the part dealing with probable cause and send it back for reasonable suspicion analysis, does that go to the trial court? And if so, would it be again based on the video? What does a remand look like?
Well, I think a remand could go to the Court of Appeals to determine whether or not there was evidence that would support reasonable suspicion. It could go down to the circuit court.
You're pretty much stuck with the video at this point.
I'm stuck with the video, right, exactly. And so it could be that on the existing record that the circuit court, and I know that Justice Hood is no longer sitting in the circuit court, he's now at the Court of Appeals. So that'd be a different judge. They have to review,
But if we find that it is not sufficient for reasonable suspicion, the odor alone, then obviously it's also not sufficient for probable cause, correct? I mean, because reasonable suspicion is a lesser standard. So if we say whatever the lower courts did, or, how it was presented to them, and they decided it based on probable cause, but we think actually the correct inquiry is looking at reasonable suspicion, if we were to conclude that the odor alone isn't sufficient for reasonable suspicion, then it couldn't be sufficient for probable cause either.
well, I need, for some kind of specificity, or would the court be saying it's not reasonable suspicion to do the investigation or not probable cause to do the search, getting to? And that's what Kazmier's deals with. So if the court is saying that the smell alone is not reasonable suspicion to even do the investigation in the first place, and certainly there isn't probable cause to, due to the search itself. I think here in these facts, you still deal with the fact that Kazmier's is still law until this court rules, and that the smell of marijuana under this court's decision, just the smell alone is probable cause to go into the vehicle. And so you have a good faith exception to this of whether or not there should be suppression of that. But that's moving forward. I guess the question would be whether the smell alone is enough to investigate or to search.
Thank you. Thank you all. The case will be submitted.